Let attendees join. Yeah, everyone. We will be starting the webinar in a few minutes. We're just waiting on everyone to join. Yeah, everyone. Welcome to today's webinar, Crossing Frontiers, Immigration Law Webinar Part 1. My name is Esanali Koja, and I'm your moderator for today. As a quick introduction to IPN, IPN is a Smiley Professionals Network and is focused on connecting Smiley professionals with each other, assisting with career and professional development, providing resources for skills development, and sharing thought leadership like this session today. Furthermore, IPN offers a number of programs and services to the community that will allow us to build on top of what we learned today, such as job placement support systems, which include resume review, interview prep, connecting with other Smileys in industries you are interested in pursuing, and as well as entrepreneurship coaching and a Slack community of professionals and entrepreneurs. If you want to reach out to us, you can do so at the email connect@ipnonline.net. If you have any questions, comments, or concerns, please use the Q&A box. I will be taking a look at that throughout the entire session. Also, today's session is being recorded and will be shared with you all. Without further ado, I would like to go ahead and introduce our speaker, Alyssa Hussein. Alyssa is an immigration attorney specializing in employment, trade, and investment-based legal status for individuals and companies in the US. Today, she's going to present about F1 student employment on OPT and STEM OPT, and on navigating your immigration options and career trajectory in the United States post-OPT. Alyssa, thank you so much for doing this, and over to you.
Thank you. Yeah, everyone. As Hassan mentioned, my name is Alyssa Hussein. I am a U.S. immigration attorney, and I primarily focus on employment-based immigration. In terms of the session today, this is a part 1 of 3 session. We're going to have another session in November and another one, in October and another in November. In terms of the topics, today is going to focus more on high level of career trajectory as an employee and navigating employment-based immigration, be it work permits or green cards. And then October session will be about startups, if you want to start your own company and sponsor yourself, what that looks like, both in terms of work visas and green cards as well. And then the final session will be just a session on employment-based green cards, because it's obviously a hot topic right now. If I don't know how involved everyone is in terms of understanding what the timelines and eligibility criteria are, but there's a lot of nuance involved in it. And so I kind of want to dedicate that session to unpacking how to navigate your career early on, or even if you are later in the game, of trying to get ahead of it while you can, because of long wait times and continued backlogs in USCIS. So we won't jump into that too much right now, but just for context, so you guys know which ones may be applicable to your situation and which may be helpful. And today the focus will be on assuming that you started or will start in the US on an F1 student visa, studying in the US, and then navigating your work opportunities beyond that, and considering your US immigration while you navigate your career trajectory. I also want to add that at the end of the session, afterwards, we will be sending out an email. And in that, we'll also include a link that you can book a 15-minute complimentary consult with me. I am offering these probably only until latest the end of November. So I would recommend, if you have case-specific questions, to get ahead in terms of booking me, because I probably won't be offering them in the new year. So I am going to try and answer as many of the questions that were submitted, and hopefully this is informational in terms of helping you understand the long-term, your long-term U.S. immigration path. But you know, if you do have more nuanced specific questions, I would recommend booking those sooner than later. But yeah, okay, we can go to the next slide. Thanks. So a little bit about myself. I am licensed in Michigan and Ontario. I'm actually based in Canada, but I practice primarily U.S. immigration and primarily employment-based. I do some family-based in terms of spousal applications, but beyond that, I don't handle anything aside from employment-based immigration. And what that means is work visas and green cards that are based off of employment, which is essentially what this whole session will kind of unpack in terms of what those types of work visas and green cards are, and then some of the nuances and eligibility criteria associated with them. And full disclosure, I am obviously an attorney presenting on behalf of my law firm, but this is not legal advice. This is for informational purposes only. And so if you do have more nuanced case-specific questions, you should talk to a lawyer directly. But yeah, sorry, next slide. Thank you. Okay, so I'm going to start with F1 employment. Today, I'm not going to be talking about work authorization while you are in school, but the focus of this will be once you've completed your studies and working after that. So most F1 programs allow you the eligibility for a post-completion OPT. What this means is that if you haven't used some of your OPT time during the school year, you would likely have at least, a total of 12 months of OPT time to work post completion of your program. There are considerations beyond that as well, which I'm going to go into in terms of when to apply and timely filing, which are very important when you're navigating work authorization, and especially in the current market when you've just finished school or you're in your third year and you're trying to navigate internships and job opportunities. And that already is a hurdle. And then on top of it, you have to keep timelines in mind when talking to your employer about whether they can sponsor you, whether they will, and what the obligations around that are. So it's very challenging. There's a lot at play, but it's just important to understand what they are so that you can best be your own advocate in that situation. If you are studying in a program that falls within a STEM designation, the Department of Homeland Security publishes a list generally every year of which majors qualify for STEM extension. But if you do, then that means that you may have an additional 2 years to potentially get for extension for after your initial OPT period. Again, timing considerations. There are also additional employer obligations with STEM OPT to keep in mind. But in terms of the two options, post F1 completion of your program, the first one is OPT, which is 12 months. And then if you are eligible for STEM OPT, that can give you an additional 2 years. And it's commonly referred to as STEM extension. Now, in terms of additional considerations, the first thing is maintaining status. You early on in your F1 career studies, you're going to be focused on your, on everything but probably US immigration. But unfortunately, your US immigration follows you from start to finish. And so when you're eventually applying for a green card, if that is something you want to pursue, you have to demonstrate that you maintained valid status every time you were inside the US previously. It's usually based off of your last entry, but if you had any time of unauthorized stay or unauthorized work, you need to be able to combat it and work ahead of it instead of kind of letting it play out and it impacting your ability to eventually get a green card. So what I recommend generally to my clients, especially early on, is keep records of you maintaining your status the moment you enter the US. So what that means is for F1s is if you are, demonstrate that you attended classes, what program you studied in. You probably keep your records of your I-20s, keep copies of everything in a folder that you'll be able to access once you don't even have access to your student email, probably on a personal email. You do end up going for OPT, keep all the documents that demonstrate your receipt notices from the government, your pay stubs, so that you can demonstrate that it was the employer you worked for was the same one that was disclosed to the DSO and to USCIS. And if it's not, that's something you want to check to make sure you get ahead of earlier, sooner than later, because these are all things that may come up later on in your immigration journey, and you want to make sure that you are best presenting your case and you're maintaining status always. There are some nuances to the implications of that. It doesn't mean that you will be banned from the US. There are ways to, if it's already happened and navigating it, it's really important to actually work with an attorney on your case specific situation. But there's it's always important to remain compliant from start to finish. And unfortunately, your DSO is not always going to explicitly tell you what compliance means. Another thing is timely filing. So just because you're eligible for post-completion OPT or STEM OPT, it doesn't mean you are guaranteed it. You need to apply in a timely manner in order to even get it. So a lot of times I actually have a lot of clients who come to me who have exceeded this period of time and haven't applied and have lost their OPT authorization or their ability to even apply for OPT authorization because they didn't keep these timelines in mind. So for post-completion OPT, the timeline is that you can apply up to 90 days before your completion date of your program, but no later than 60 days after the completion date. So what I recommend if you're in this position is if you already have a job lined up and someone who's willing to employ you, you want to start gathering the documentation that's needed in advance so that you can submit the application closer to the 90-day mark as opposed to closer to the 59th day after completion. And there's nuances to this, difficulties, challenges if you don't have employment lined up, but it's something to just keep at the back of your mind in terms of having all of your documentation ready so that once you do have a job lined up, you know that you're ready to submit. For post-completion OPT, your work needs to be related to your area of study. For STEM OPT, there are additional employer compliance rules as well. So oftentimes, even though your employer was able to employ you under post-completion OPT, that doesn't necessarily mean that they will be able to continue when you're in STEM OPT. So that's another thing to keep in mind in terms of having conversations with your employers, again, sooner than later. It's tough because, obviously you want to be able to keep your job. You want to not show that you need that support, but the reality is that you do. So if you get ahead of that and have those conversations, then and demonstrate to the employer that you can handhold them in the process, that will probably help you retain employment with them if you demonstrate that you are here to help them through that process as well. Okay, so timely filing for STEM OPT, the timeline is you can do so up to 90 days before the expiration of your initial OPT period. The application needs to be received by USCIS before your previous OPT expires. And then there's a grace period where if you submit it in a timely manner before that expiration, you can continue working up to 180 days after the initial OPT expiration if you don't receive the approval for the STEM OPT before that. That being said, the reality is that in OPT, especially for STEM OPT, most educational programs are around the same time frame. And so a lot of students are submitting these applications and USCIS gets backlogged, which is why they've created this extra 180 days for people to work. But what often happens is people will submit their applications at the last day, and after the 180 days, they will run out of work authorization. And then they come to me and they say, what can I do? And so if you want to keep your OPT time, you need to wait until it's adjudicated. If you switch to another work visa, like an H-1B, you can't then use that OPT approval and you've used up those 2 years. So that's a choice that you have to make, which is why it's really important to get ahead of it. Because timeline-wise, what that means is that 9 months into your initial OPT employment, you would need to be submitting your STEM OPT extension, assuming, of course, that that employer is also an eligible employer. So you need to be thinking about who's going to be your employer early on, and it's good to have those STEM OPT conversations with your initial OPT employer at the start of your initial OPT, so that you can understand what potential challenges you're going to have to face and timelines that you need to take into consideration. Another consideration is immigrant intent issues. I'll be touching on this throughout this session, and you'll hear it in the rest of my sessions because it is probably the most important and least understood concept in US immigration. F1 visas are a non-immigrant intent visa. What that means is that when you enter the US on an F1 visa, you cannot have the intent to permanently immigrate to the US. That permanent immigration is something like a green card. So it is technically misrepresentation if at your point of entry, you intend to apply for a green card. So every time you enter on F1 status, you need to think about your intent and how you're communicating this to the officers that you are talking to when you enter. That being said, there are, I will go into what the various green card applications are and what they're referred to, but most employment-based green cards, except for PERM, is a 2-part stage. The first part is an I-140, which isn't the green card application itself, but is your eligibility for a green card category. USCIS has guidance that says that submitting an I-140, an adjudication of an I-140, and even approval of an I-140 does not automatically create immigrant intent issues. However, it does raise a potential issue of you potentially needing to demonstrate to the officer that you intend to return to your home country or leave the US at the end of your F1 status. And so this is really important to keep in mind, because a few of the other work visas I'm going to talk about too are also non-immigrant intent. And so while you're navigating your green card journey and profile building and doing all of that, you need to also consider that you need to remain compliant with your work or student authorization that you're allowed in the US. So the way that you generally, at the end of the day, everyone's circumstances are different. It's important to, again, consider your specific circumstances, talk to an attorney if you're unsure. But generally, for immigrant intent, to demonstrate that you don't have immigrant intent, you can demonstrate ties to your home country, which include, but are not limited to, having property in your hometown, having a potential job lined up, having family, having bank accounts. But you really want to demonstrate the stronger ties you have to your home country, the less issues that are potentially brought up. And unfortunately, the reality of the system is that not all countries are treated equal, not all nationalities are treated equal. And so depending on which country you're coming from too, there may be higher scrutiny on your intent. And that's also something to keep in mind, to just make sure that you have that documentation ready to present if it's ever raised. And then the next 2 things that I want to raise for OPT are grace periods and unemployment. For both OPT and STEM OPT, grace periods are 60 days. What that means is if your OPT time has expired and you don't have sponsorship lined up immediately, you get a 60-day grace period. This does not allow you to work inside the US. It only permits you to stay inside the US and basically close out things, find new employment, do a change of status with a new employer or a same employer with a different work visa. But you cannot work during that time. And if you want to stay inside the US, you need to timely file an extension within that 60-day period. And that can include a change of status to visitor status, because if you didn't end up attaining employment in time, you want to buy a little bit more time, like 3 to 6 months, to close out your lease or anything like that. You can ask the government for an additional period of time, and then end up switching to another work visa once you've secured that. Again, more nuanced than just what I'm saying, but these are just considerations to keep in mind. And then unemployment on OPT, on post-completion OPT, you get 60 days. For STEM OPT, you get an additional 90 days of unemployment time. What that means is if you didn't use your 60 days in OPT, you get a total of 150 on your STEM OPT. This is where record keeping and maintenance of status is also important, because you want to make sure that you kept your receipt notice that showed a receipt date that was before the completion date or within the 60-day completion date of your program. And then you worked for an employer, you have those pay stubs, but then you were unemployed for maybe a month. So you want to show that you don't have pay stubs then, but then you did get pay stubs the following month. And that shows how many days you were unemployed. So keeping that documentary evidence is your whole big picture immigration journey that probably won't come up until you're at the green card stage. So it's really important to keep this documentation, and it may never come up. An officer may never ask you, but for the ones that it does, it's going to make or break your case, and you want to make sure that you demonstrated that you were always compliant. Because unfortunately, there's a lot of in the space of immigration, there's a lot of fraudulent employers out there. USCIS doesn't always make the correct decisions, and so you want to make sure that you have the evidence that demonstrates that you were following the rules. Okay, now I will jump into work visas. Thank you. Okay, so these are not all the potential work visa options that are available, but the ones that are generally used for professionals. So I kind of limited it down to that. But again, if there's another industry that you work in or are interested in anything else, you can always reach out. But in terms of like career trajectory, thinking of someone who generally was in an F1 and is now considering work options post F1, these are a few of the options. So there is the TN visa, which is only applicable to Canadian and Mexican nationals. That means that you are a Canadian or Mexican citizen. You don't have to be born in Canada or Mexico. So a lot of times people will consider moving to Canada, attaining Canadian citizenship, because sometimes it is a lot faster, and then eventually going back to the US on a TN visa. TN visas are specific to certain occupations. There's a whole list of occupations that qualify. Not only does your job need to fit into the occupational, the occupations that are stated and the specific job duties, you also need to have the matching educational requirements. And so TN visas are quite limited and more structured, but there is a little bit of wiggle room. There's an occupation in the NAFTA list that's called technical publications writer, and I've done TN visas for content writers to fit in that category. So there is some wiggle room, but it's really very specific for the most part. TN visas are also non-immigrant intent visas. What that means, again, is that people on TN status cannot have, when they enter the US, the intent to immigrate permanently. So that's a limitation to keep in mind. There are no maximums on the number of times that you can renew. And so that's a benefit of the TN visa. They're generally issued for a period of 3 years. And if people are Canadian, then they are visa exempt. They don't even have to do visa stamping, but Mexican nationals need to. The next visa is probably the most sought after visa when people realize that it's oftentimes, depending on circumstances, less limiting than the H-1B, but it has a little bit of a higher standard to meet in order to be eligible. So the O-1 visa, you need to have a petitioning sponsor that can either be your employer, that can either be a company that you own, a US company that you will be working for, or through an O-1 agent. So an O-1 agent that can be a US company, a US citizen individual who basically will be overseeing your employment. But if you have an employment agreement with another company, that employer, even though they won't be submitting your petition, that employer needs to explicitly state that they are allowing this O1 agent to submit this application on your behalf. So the employer would need to be on board with your O1 agent submitting the application. But it does allow a little bit more flexibility where employers are sometimes not willing to submit the immigration petitions. They don't want to be involved. They're just like, you handle it and show us your work authorization. So it allows for that kind of flexibility. The other element to it, which is the larger hurdle to meet, is that you have to meet 3 of 8 eligibility criteria. This is referred to as the extraordinary ability visa. And the 8 criteria are high level. I'm going to try and remember. Awards, press, you need to have created original contributions of substantial significance. You need to have worked in a critical capacity at a distinguished organization. You need to have made a high salary. You need to have published work. You need to have judged the work of others in your field, or membership in associations within your field, selective organizations and associations in your field. So that's 8. You need to meet at least 3 of those to qualify for the O1. High level, that seems like you may be, publications, scholarly articles, things that you did while you're in school. Unfortunately, USCIS doesn't count all evidence. So a scholarship to your university or an award you received at your university generally won't count, but a more national acclaimed one will, that's specific to your field. So oftentimes when people are navigating their work visas, they are doing what's referred to as profile building to meet the O1 standard. And because that allows a little bit more flexibility in terms of what kind of employment you can take, there's no requirement on how much your employer needs to pay you, which does allow a little bit more opportunity and flexibility on the employer's end. If you did want to work for a startup that was, paying less in salary, but more in equity. And so the O1 visa is a common visa that is oftentimes you need a little bit more time to meet that criteria, but once you do, there's no limitations on how many O1 visas you can have over periods of time. It's initially issued for 3 years. Extensions are for 1 year, but if something changed in your employment, something major, then you can also keep requesting additional 3 years. So it's a great one of my favorite visa categories. The next one is an L1 visa. Sorry, I'm going to go back to immigrant intent. O1 visas are not non-immigrant intent visas. They are also not dual intent visas. They are in the middle ground. So you can have a pending green card application. You can have the second stage 2 while in O1 status, and they cannot revoke your O1 because of your immigrant intent at the time of entering because you had a pending green card application. However, they are still not explicitly dual intent visas. So what that means is while your green card application is pending and you're inside the US, there are still some travel limitations to that, which I will get into in the green card session in November. Okay, next visa is the L1 visa. It is a dual intent visa, which means that you can have the intent to apply for a green card as soon as you enter on an L1 visa. It's the intercompany transfer, sorry. It's either a managerial role or a specialized knowledge role. To be eligible, you need to have worked in a foreign country for the entity, the US entity, for at least 12 continuous months within 3 years. And then that entity can transfer you to their US office to work for them in either a managerial role or a specialized knowledge role. There are limitations to this. If you come in as specialized knowledge, you're limited to a max of 5 years. If you come in as a manager, you're limited to a max of 7 years in L1 status, which means after that, you cannot extend on L1 status. So you need to have figured out what your next work authorization is going to be beyond that, or you pursued a green card while you're in L1 status and timing wise, it worked out. Another benefit of the L1 visa is that If you have a spouse, they would be on an L2 visa and they would be permitted to work. They would have an open work permit. A limitation of this is obviously that this ties you to your employer. You need to have worked for the employer abroad. You need to work for the employer inside the US to maintain that status. And there's a green card route that may be applicable if you do come in as a manager under this route, but again, ties you to that employer. The next visa is an H-1B visa, very common. A lot of people know what this visa is. Usually to qualify for an H-1B visa, you need to be selected in the annual lottery. You generally need to have at least a bachelor's degree. If you don't have a bachelor's degree, you need at least 12 years of equivalent experience to make up for that bachelor's degree. And then the annual lottery starts in March for the most part. Selections are made in April. Submissions are made in June. And then you can work as early as October 1st of that fiscal year. Sometimes there's second rounds of lotteries, but for the most part, this year there was a second round, but for the most part, there's only ever one round. I know people who have been trying every year and are not selected. So best case scenario, your employer's on board, you're selected, and you do this while you're in STEM OPT or in OPT, and you got your selection, and then you can switch to H-1B after OPT, and that's the best case scenario. Unfortunately, most people aren't selected. So what that means is if you don't qualify for the rest of the other work visas that are listed here, another option may be to pursue a CAP exempt H-1B or a concurrent H-1B with a CAP exempt organization. So a CAP exempt H-1B is where you work for an organization that is CAP exempt. They are exempt from the annual CAP, which is the lottery. This includes certain research organizations, certain not-for-profits. You have to consult with the lawyer or speak to the employer to determine if they are CAP exempt or not, but there's a lot of organizations that are CAP exempt that actually do support employees in trying to navigate private employment. So that's what's referred to as a concurrent H-1B. So what people often do is they will gain employment with a CAP exempt organization. There's a few organizations that do this. There is, I'll send the links afterwards, but one of them is Open Avenues, and there's the Build Fellowship, and another one that I'm blanking on right now, Global in Residence, which is state specific. That's more for startups. But what they'll do is you apply to them. They will determine if you're eligible or not. Sometimes it'll include 5 hours of work to mentor people within your industry and to work with the university. They will submit your CAP exempt H-1B petition any time of the year. There's no limitation on it being March or October. Then, as soon as that is submitted and approved, your private employer, who's trying to keep you employed on a full-time basis, assuming it was post-OPT or you worked for them at a period of time where you've navigated that part of your career and they're on board, they will then submit a concurrent H-1B application, which will not be subject to the annual cap, which means that so long as you are retaining your cap exempt employment it's going to be a part-time 5 hours per week, you can work full-time for your private employer on that H-1B as well and not be subject to the annual cap. Obviously that sounds too good to be true. There are nuances to that. It's very expensive. Your private employer needs to pay a lot of the fees because with H-1B, due to Department of Labor regulations, they can't offset those costs, a lot of those costs to the employee. H-1B visas also have prevailing wage requirements of how much you're supposed to be paid based off of your geographic location and your specific role. So H-1B visas create a lot of compliance issues on the employer and can be quite hefty in cost. They're limited also to 6 years, unless, like with some caveats to, if you have an approved I-140, you can continue extending. An I-140 is that first stage of the green card process that I mentioned. But more nuances to that I will go into with the green card conversation, because most of the work visas that are implicated in the green card conversation are only applicable once you're actually considering the green cards, which I'm also going to jump into today too, from a high level. So those are the 3 potential H-1B routes. There's a few other work visas that you may be eligible for based off of your country of nationality. There's the E3, which is for Australian citizens. Again, you don't need to be born there. E3s are very similar to H-1B visas. You have to be working in a specialty occupation. And then there's the H-1B1 as well, which is also specialty occupation if you're a Chilean or Singaporean citizen. Again, don't have to be born there. And then there's E2 or E1 visas, which are more applicable to if you have your own company, if you're an entrepreneur. These are work visas that are based off of treaty trade or investment. But there is E2 and E1 employees. So if you work for an employer who is on one of these visas and you're the same nationality as them, they can bring you in as an employee as well. So, I mean, that's a very specific type of employer to look for, but if that's ever something that may be a potential, if you're from a treaty national, you have to be a citizen of a treaty national country. So Canada's on that list. India, unfortunately, is not. Pakistan is on that list. And so what if you know entrepreneurs who are the same nationality as you and who do fall under who are in a treaty national country, then that may be a conversation you want to have in terms of if you want to work for their company and it's aligned with your career and makes sense with what you're doing, but there's an opportunity there as well. Okay, let's go to green cards. Okay, so these are the employment-based green cards. I'm gonna explain how the green card process works, high level again. Like I said, for the most part, it's a 2-part stage process. So everything that's listed there, except for the last one, which is EB2 and EB3 perm, all of them are a 2-part process. EB2 and EB3 perm is a 3-part process. So I'm going to start with the 2-part and then we'll get into perm after that. When you apply for a green card, you first submit an I-140 to demonstrate your eligibility based off of these criteria, which I'll give you high level. Then there is this thing called priority dates. I'm just going a little slow because I want to make sure I can explain it as well as possible. So when you submit these applications, the day that USCIS receives it, except for perm, the date of their receipt becomes your priority date. On a monthly basis, DHS will publish what's referred to as the visa bulletin. And there are a limitation on the number of visas that are allocated per country and per visa type, immigrant visa type. So they tell people how long the wait is before someone's priority date is current. You can only apply for your green card, which is the second stage, when your priority date becomes current. Your I-140 doesn't need to be approved by the time you do that. In the current climate of US immigration, you ideally want your I-140 approved by the time you apply for the green card, because if there ends up being a denial and you're applying from inside the US, if you don't have an underlying work authorization that is, a dual intent one that allows you to keep renewing, that really puts you in a position of having to scramble to pull things together. So generally, again, everything requires you to consult a lawyer on your case specific situation, but generally you want to apply for stage 1 first, assess where you're at, and then apply for stage 2 once your priority date is current. So all of these ones, so EB1A, EB1B, EB1C, EB2 national interest waiver, those are all the I-140 eligibility. Once your priority date's current and you then want to apply, you have 2 choices for your green card. You can apply from inside the US and you can do what's referred to as adjusting your status. This allows you to adjust and apply for your green card from within the United States. However, unless you're on an H-1B or an L-1, that means that you must stay put inside the US until your matter is adjudicated and you receive your green card, which is quite a lengthy wait time. It's about 2 years. Or you can also submit a travel document application, which will allow you to travel, but wait times for that are around a year as well. So it kind of limits you to stay inside the US and limits your travel outside. Another option is to consular process. And what that means is that you, in order to, once your priority date is current, you can go to the visa center in your home country or a country that you have ties to outside of the US and go and do your interview there and pick up your green card document, so then you can just get it when you re-enter the US. I say that to say that it's the adjustment of status application that really raises the immigrant intent issues. So all of the immigrant intent issues that we have raised in terms of TNs, F1s, it's really that stage that raises that issue. So when you are in any of those statuses and you are applying for an adjustment of status, you need to really carefully consider any travel that you're going to be pursuing in the midst of it if you want to maintain your underlying status. Okay, now I'm going to jump into the eligibility criteria of these green card options. So EB1A is the extraordinary ability. It has the exact same eligibility criteria as the O1 plus 2 more. So instead of 8 criteria that you need to meet 3 of, you have 10 criteria that you need to meet 3 of as well. EB1As are very sought after because, again, I'll be diving deeper into this into the green card session, but in terms of where people are born, that's what determines how far along you are in the visa bulletin, and EB1As are a first priority. So a lot of people who have longer wait times for green cards, who are often Indian-born nationals, pursue an EB1A because it's a shorter wait time than if they pursued an EB2. With that being said, and with the current immigration climate, a lot of people are submitting EB1A applications. There is a lot of scrutiny on them. There's a higher threshold than an O1. Just because you qualify for an O1 doesn't mean you qualify for an EB1A. So it has very similar criteria, but you need to have a stronger picture of how you are contributing to your field, that you are really at the top of your field in that industry. So the reason it's important to understand this is because if you are an F1 status and you are an Indian-born national and you want to pursue an EB1A, you need to start profile building now to be able to demonstrate so that in your next few years of your career, you are eligible to apply for an EB1A sooner than later. Again, I'll be doing a green card session that goes in the ins and outs of all the eligibility criteria, but just giving high level here. So EB1As, if you're an outstanding professor, usually people who work at universities apply for this one. EB1C is multinational manager. Like I said, this is the one where if you're on an L1A intercompany transfer, where you worked for an employer abroad for 1 full continuous year as a manager, and then you worked for them in the US for 1 full continuous year as a manager, you are eligible for an EB1C. So that, again, is a great way to get a green card, but it ties you to your employer. But in terms of a strategy that a lot of people use is they'll work for their employer abroad and come back to the US and then get on that green card stage. Depends on the relationship you have with your employer. And when I talk about, in October session, I'll talk about startups and having your own company. You can pursue an L1A visa starting your own company, which then doesn't tie you to another employer. It ties you to yourself and your own company. There are additional considerations in pursuing that, but that is another route to potentially, if you are an entrepreneur who wants to do that, is set up your company abroad, work for it abroad for a year as a manager / executive, and then open up offices in the US, and then pursue a green card, EB1C green card. The next one is the EB2 national interest waiver. That is probably one of the green card visas that I do the most of, national interest waivers and O1s. EB2 NIW, which is what it's referred to, is a little less structured in terms of how to identify a checklist of how to qualify. What you need to demonstrate is that you either have an advanced degree, which is a master's, PhD plus, or if you don't have an advanced degree, that you have a bachelor's degree and 5 years of experience in the field to meet the first criteria. The second and third criteria is that you are going to be contributing to work in the US. This is what's called your proposed endeavor. And that proposed endeavor is going to be in the national interest of the US, so much so that you're requesting for them to waive a labor certification process. And then additionally, that you are best positioned to pursue that. So this really is up to, like, depends on the nature of work you're doing. If you're an employee, it'll depend on, you know, what kind of company you're working for, who they're serving. Even though this green card route doesn't require you to have that job lined up, that potential endeavor lined up, it's not going to get approved without clarity on how this is happening. Have conversations happen. Do you have an employment agreement? If you're doing your own company, do you have letters of intent of clients wanting to work with you? And then beyond that, what is the national interest you're serving? So that can include healthcare, biotech, semiconductors. Within AI, people think that as long as you're in AI, you qualify. It needs to be very specific on who you're serving and what kind of communities you're serving. So if you're serving marginalized communities, and it needs to be of national importance, it can't just be, there's actually case law that says that educators, unfortunately, don't qualify because, and especially like teachers, because they're so targeted to one small population and their knowledge isn't spread nationally. So ultimately, it's a lot of brainstorming. It's a lot of working in terms of what the impact you're going to have is going to be. And so again, there's a profile building component to this. For both the EB-1A and the EB-2 national interest waiver, you can self-petition, which means that your employer doesn't have to be the petitioner for you. The benefit of that is that while you're waiting out this green card, while you're continuing to potentially work for your employer in work visa from the previous list, you have a priority date locked in that is also not tied to your employer and doesn't tie your whole US immigration career and how you pursue your life based off of whether you get laid off or not. So there's a benefit to that. Again, I will jump into the details of it in our session in November. And then the last one is EB-2 and EB-3 perm. This is an employer-sponsored green card route, in which there's a labor certification process. These didn't used to take so long, but unfortunately in the current backlog and Department of Labor's processing time, these take really, really long. So if this is the route that you think you'll only qualify for, it's better to have those conversations with your employer sooner than later. There's a lot of employer compliance involved with perm applications. And like I said, instead of it being a 2-part process, it's a 3-part process. So the first part is that your employer will conduct a labor certification test for your role specifically. And they'll demonstrate that there's no similarly qualified US workers for their role. That process can take over a year. After it's way over a year now, but after that perm comes in approved, then you can submit your I-140 that's related to that perm, and you'll demonstrate to USCIS that, well, your employer would be demonstrating to USCIS that you are most qualified for this, and that they conducted a labor test and didn't find anyone else, and hence why they should hire you for this. And then once your priority date is current, you can adjust status to your green card, or you can consular process and apply at the visa center for your green card. For perm, your priority date won't be based off of your I-140, so it is the earlier date from your perm that actually counts, but it's a lengthier process and does tie you to your employer in very many aspects. And, you know, in terms of if you're on H-1B and you're in your first year of H-1B, you should have these conversations with your employer now, so that timeline wise, you are at least eligible for your green card, hopefully before your H-1B time's out. That being said, like I said, H-1B is the only one of the visas that the time period can be extended. L1s can't, where it with an approved I-140 or a pending I-140 for a certain period of time, you can keep extending your H-1B. So again, a lot of nuances here. I just ranted for 50 minutes. So I don't know if there are any questions that I can go through the questions. What I'll do is, I'll go through the questions that were submitted.
Sure.
First. Yeah. Okay.
Yeah.
Okay. So, oh, actually, there's one more slide now that I see. The next question that I see is, how does a mid-career professional best navigate their career in the US labor market? And so challenges to attaining sponsorship, I totally forgot I was going to address this, is that, you know, obviously a lot of these categories require employment sponsorship unless you're going to be starting your own company. Or self-filing for your green card petition. And what that means is that you not only need to navigate US immigration, you have additional networking to do beyond what US citizens and green card holders in the US have to do to navigate getting jobs. What that means is, I mean, I know IPN has like a realm of resources that are available. What that means is get ahead of networking, build relationships, do cold outreach, and not in a way of just asking for jobs, but building relationships so people get to know you, talk to foreign founders, foreign employers as well, who have done this themselves and understand the nuances of it, but also the value of hiring foreign workers in the US and the value that everyone here brings, and take control of your journey in a way that demonstrates to them that it wouldn't be a burden and you'd actually be supporting them through this whole process, and how your support through it can even allow them to even hire more people like you moving forward. That being said, it's tough, right? Like the big companies have a question in their applications that say, do you now or will you ever require US sponsorship? And then you're probably out the door at that point. So I think it's about creating and establishing direct relationships, you know, something I've found valuable. I myself am not a US citizen. I am, you know, I was on F1 in the past myself, is reaching out to people in my industry, asking them for advice, reaching out on LinkedIn and being like, hey, could we do a coffee chat? Would love to pick your brain. And you build these relationships slowly to kind of, you know, when they are employing someone, they're like, okay, I'll do that additional work because I want to hire you. And then in as a lead up to the fact, my next session is you can start your own company if that's something, if you want to be an entrepreneur, if you always wanted to do that. It also allows you to take control of your own immigration journey and not put it into your employer's hands, which is a great position to be in as well. So I'll kind of, yeah, that's kind of the next session that I'll be going into, and really unpacking how to do that and the nuances to that as well. Okay, I'll do two questions from the ones that were submitted. And then after that, because I've been talking for so long, after that, if you guys have any other additional questions, you can always email me at info@crossingfrontiers.ca. We'll circulate the link, the booking link, at some point after the session, for you to be able to book a one-on-one complimentary consult with me as well. They're 15 minutes long. Come prepared with your questions so I can hopefully be as valuable as possible. But yeah, I did see a question related to how far in your H-1B time should you then apply for a green card? So I know that even today I kind of talked about work visas and then green cards. There's a common misconception that you need to get a work permit first and then apply for a green card, which isn't true. You can, even if you are not in the US right now, never have been in the US, you can immediately apply for a green card so long as you're eligible and meet the criteria. There's no requirement that you need to have attained work authorization in order to pursue a green card. They're separate and distinct processes. The only thing is that some of the work categories limit your ability to apply for a green card because of their non-dual intent limitation. So that's something to keep in mind. So if you're on H-1B, that's a dual intent visa. You can, if you're eligible right now, you can apply immediately. It just depends on whether you're eligible for the green card itself. And actually being on H-1B is a better situation than being on a TN, for example. But still not possible. Okay. Sorry, I'm just going through the questions. I think for the most part, I addressed all of these ones.
There are a few questions in the chat that that are very specific.
Yeah.
Do you want to go through some of those, or
Sure. I can see them popped up on my end, so I can address some of them. So are dependents allowed on the O1? Yes. Oh, dependents, so spouses and children get an O3 visa. However, dependents are not allowed to work. So O3 spouses cannot work. So that is a limitation of the O1 visa. How do you apply for the lottery? So H1Bs, so assuming this is the H1B lottery, H1Bs are
popped up this question popped up while you were talking about H1B, so I'm assuming it's regarding that.
during about that one. Okay, perfect. Yeah. So the application process for the lottery is dependent on your employer being on board. The employee doesn't submit anything. The employer themselves submits the lottery registration. Up until this year or this upcoming year, it was only $10 for an employer to register. That fee has now gone up to $215. So it used to be not a huge burden on an employer to be able to register a bunch of applicants. That burden may be a little higher now. For the registration itself, all the employer needs is the candidate's passport. And I mean, they should review if the person has a bachelor's degree or not, and the employer needs to be the one to submit it. So I'd say that's the process. It comes out in early March, but you really need the employer on board to register. Okay, is there a location rule of staying within 50 radius miles of your company's on-site location for F1 and H1B visa holders? There is for H1B. You need to stay within the same 50-mile radius of your the MSA. I never remember what MSA stands for, of the MSA region on your LCA. So lots of acronyms. The LCA is a labor certification application in the H1B petition. That is where your employer will disclose your worksite location. A lot of people work remote, so they'll put the potential offices of where you may go to work, and if you're working from home, also your work address. So if anything that's not disclosed on that LCA needs to be within that 50-mile radius of the locations that are disclosed for an H1B. For F1s, there is no such requirement. Okay, I'll do one more. Can we file EB2 NIW staying in the US on F1 or F2? Yes, but only the I-140 stage. If you're eligible for an NIW, only submit the I-140. Do not submit your priority date probably isn't current unless you have a previous one. But if you're on F1 status, the moment you submit an adjustment of status, you now have immigrant intent. So you want to make sure that unless you plan to not leave the country and not travel, you want to only apply for the I-140 at that point and be prepared to answer questions if you are traveling for an officer to raise for you to demonstrate your ties to your home country. So just be prepared, I would say, and I would advise to seek independent legal counsel because everyone's situation is different. If you don't have enough ties to your home country, depending on your country of nationality, you want to just make sure you have all bases covered. But yeah, okay. I don't think I can go through the rest of the questions, but I do hope the session was helpful. I look forward to doing it again, obviously on a different topic for startups in October and then green cards in November. And everyone will get the link to book a one-on-one with me at some time this fall as well. So I do recommend doing that if you do have more specific questions.
Absolutely. Thank you so much, Alyssa. That brings us to the end of our session today. I would like to thank our amazing speaker, Alyssa, once again for this insightful webinar and for her time today. The webinar would not have been possible literally without her, and we cannot thank her enough. I would also like to thank all of you for attending and listening today. Obviously, there are a lot of questions that are very specific questions that we will not have time and do not have time right now to get into. However, please be on the lookout for a follow-up email with the recording link of today's session. And as Alyssa mentioned, we will also be sending the consult link as well along with that. IPN is here to help you connect with each other and help you in your career, professional development, and entrepreneurial endeavors. Please reach out to IPN with any questions and requests at the email address connect@ipnonline.net. Once again, that is connect@ipnonline.net. Stay safe and Yalamadhan.
And with that, everyone, thank you.